number 144, People versus Lewis Speaks. Counsel?
Good afternoon, Your Honors. May I reserve 1 minute for rebuttal, please?
You may.
May it please the Court, now Tarai from Appellate Advocates here on behalf of Appellant Lewis Speaks. I'd like to address the issue in reverse order, starting with ineffective assistance of counsel point. This case ultimately came down to the identification testimony of 3 eyewitnesses, where one of the witnesses identified Appellant as a shorter robber, which Appellant clearly was not, since Octavius William came to trial and admitted that he was a shorter robber. And 2 other witnesses made identifications under questionable circumstances. And the defense was mistaken identification, and defense counsel's clear strategy throughout trial was to challenge the reliability of the people's identification evidence. Nevertheless, during the prosecutor's summation, defense counsel repeatedly failed to object when the prosecutor made arguments which had no record support and distorted the evidence that related to the key identification issues. And this misconduct here, just as in Wright and Fisher, went directly to the central issue at trial and unfairly bolstered the people's case. Focusing on 2 of the more egregious comments. First, although Major testified about seeing the tall robber's face only for 3 brief periods of time.
I'm sorry, counsel, are you suggesting that it's the prosecutor's summation comments that deprived the defendant of a fair trial, or the defense counsel's failure to object to them?
It's defense counsel's repeated failure to object to the prosecutor's summation misconduct. And the misconduct here went directly to the central issue at trial, which was identification. And so there was no strategic reason. And that's exactly the identification was what defense counsel challenged throughout trial, and there was just absolutely no reason.
I'm not saying that we will, but if we disagree that the comments by the prosecutor were not improper, then that would not be an effective assistance of counsel to not have objected to it. Do you agree?
If the comments were not, if the prosecutor
comments were proper comments.
If the prosecutor made proper comments, then there was no reason for defense counsel to object. But here, the prosecutor's comment went beyond what's fair comment from the evidence. She clearly grossly distorted the evidence when when Major testified that he saw the tall robber for 3 brief periods of time. Rather than the prosecutor here distorted that evidence, and during summation played this video for 10 minutes and repeatedly said, Major was seeing this robber's face the entire time. During this whole 10 minutes, he was looking at this robber's face, the taller robber's face, and that's not what the evidence showed. And this, but however, the way the prosecutor distorted the evidence really grossly bolstered the reliability of the this eyewitness's identification, yet defense counsel did not object at all.
Similar. Are you talking, I'm a little confused, are you talking about the Anderson identification that was brought in as hearsay allegedly by Detective Henry?
This one I'm talking about was Wilton Major, which was the first
one of the witnesses
who testified, and similarly another witness who testified, Mateo, said that she saw the tall robber's face for twice for a couple of seconds.
The dissent laid out the arguable deficiencies in each one of those. If you could, I'd like you to focus a little bit on the issue of the testimony of the identification or the description that was given by Anderson that Detective Henry used. Mm-hmm. You want to address that?
Yeah. So regarding the description, first Anderson didn't testify at trial, and the problem here was that this description was ostensibly introduced to explain police action, but here police action was first off not at all relevant. How the police ended up seizing upon my client had no relevance at all at trial, and people never actually tried to elicit.
But isn't it relevant if it's an identification case? How they came to find this defendant and charge him with this crime? Wouldn't that be relevant if you're saying it's not the right guy?
But the people didn't try to introduce how this particular description that Anderson gave did not factor at all into how the police came upon my client. And in fact, the people never tried to even introduce how how the police ended up seizing upon my client. That was not at all relevant. What was relevant was whether these three eyewitnesses who testified at trial were able to make the accuracy of their identification.
Isn't your argument, though, premised on the assumption that the jury would not follow the court's instruction on this? So in other words, if the jury followed the instruction and said, well, I don't see a connection, then they're going to disregard the testimony, and if they do find a connection, then they'll consider it for that purpose.
Well, the jury couldn't have followed the instruction because there was no connection between this
They
description.
wouldn't have used it for anything. I mean, it's a hearsay violation. There's no confrontation clause issue here. It wasn't raised, so it's a hearsay violation. They get a hearsay instruction. To the extent it's relevant, they can use it, but to the extent it's improper to consider it for the truth, you can't.
But I think here, in this case, there was no way for the jury to use it for a proper purpose because it didn't relate at all to any sort of, it wasn't relevant to how the police seized upon my client. It wasn't connected.
They should use it for nothing. I mean, then you're assuming they used it for something. But Judge Stein is saying they were instructed the only way you can use this is for X. Police steps subsequent to this identification. So if the instruction from the judge is you can only use it for X and X really doesn't become an issue, why do we assume they used it for the improper purpose?
I think here, though, because this case came down to identification and this description was somewhat, was similar to what my client looked like, and my client's size was fairly unique, I think the temptation here would have been for the jury to use it for its truth, to hear that,
Counsel, but you mentioned there were two other eyewitnesses who testified, and I think you mentioned Mr. Major. And my recollection of the record is that when he was asked questions about who, the suspects or the robbers were, he pointed to your client immediately without even being, well, maybe he wasn't even asked. He just said, there he is. There's the guy sitting at the table without even any questions. So he was making this in-court identification, and he had been in the store when it was robbed.
Major made an in-court identification, but there were problems with his in-court. There were problems with the reliability of his identification. First, immediately after the robbery, he wasn't able to provide a description to the police. He told the police he wasn't even sure if he could make an identification. Further, he had very little recollection of whether the man had facial hair or if he was wearing a hat, which suggested that he didn't really get an opportunity to see this man's face. And maybe he was able to glean this man's size, but just seeing the size, I mean, Wilson also gleaned the taller Robert's size.
Isn't that all for the jury?
Pardon?
Isn't that all for the trier?
But it all goes to the harm, Sarah, and it goes to show that this evidence, it was not very strong. The people's case was not particularly strong. So allowing this implicit identification testimony, implicit description that ended up becoming an implicit identification was not harmless.
What's your strongest case for several eyewitness identifications that are weak but point the defendant are not harmless error? Do you have a case that's strong enough to support that proposition?
A particular, well, we know that there are problems with identifications, and that the social sciences show that there are actual weaknesses with identification. In a
Is there
case like
expert
this,
testimony to that effect in this trial?
not in this trial, but defense counsel did do a good job of trying to elicit all of this, and that also makes the reason why during summation, when he failed to object to a lot of these summation misconduct, it was ineffective assistance.
I'm sorry, one last question. I'm sorry, Chief.
Yes.
We're reviewing a hearsay ruling, right? So what's our standard of review?
Whether it deprived my client of fair trial.
It's an abuse of
It's
discretion,
abuse
right?
of discretion, yes.
So we're reviewing whether this trial judge abused their discretion in admitting this testimony.
Yeah.
Thank you, counsel. Counsel?
Good morning, Lori Glackman for respondent. I want to start off by talking about preservation. This entire claim is not reviewable by the court because
You're talking about preservation on Anderson,
on
on the entire claim?
the entire claim.
Go ahead.
Counsel objected, one-word hearsay objection. The court effectively sustained that objection. The court agreed that it was hearsay and issued a ruling on it saying it's not to be considered for its truth. And
But went on and talked about the very issue that they're now discussing, and so doesn't that provide a basis for our,
no, the court did not expressly decide the issue, nor could it, because the detective, he hadn't testified yet about his investigation. So it
said he was going to admit it for that particular purpose. So so clearly made a ruling on it. Now, whether, something else may have happened after his ruling.
Well, the court, if I may for a second, said that I'm going to allow it to explain why this witness did whatever he may have done, because the detective hadn't testified to it yet. So in order to properly expressly decide this, it would have had to be brought to the court's attention that, wait a minute, you made a ruling that you were allowing it in, effectively subject to connection, but it was never connected.
Assuming it was preserved, whether we, ultimately think it is or it isn't, assuming it was preserved, do you have some comments you want to make toward the state
Oh, yes,
merits of it,
absolutely.
counsel?
Thank you.
Okay, can you focus on, I'd like you to focus on, this is the way I read the summation of the proof that the dissent laid out. First off, Major, I'm talking about the witnesses now. There's 4 witnesses we need to talk about. Major, after crime, did not give any description. He gave a description first time at, I think, 7 months afterwards at the lineup in the photo array. There was no description after the time of Major. Wilson's the second one. He misidentified the defendant as a shorter robber, and he didn't view the lineup. You can correct me if you think I'm wrong. Third one, Mateo ID'd the defendant for the first time in the trial 2 years afterwards and didn't identify him either the lineup or the photo array. And then Anderson, his description was given, but Anderson, of course, that's what we're here for. We're arguing about the hearsay question on that. So those are the four witnesses that our primary witness usually identifying, plus the surveillance video. So if we set that aside, set all 4 of those aside, we still get to the surveillance video, which I went and looked at, and I don't know if it's dispositive one way or the other, to be honest, objectively. I can't say that now. But I think you need to focus there.
Okay.
Okay.
I'll start with Major. He did tell the police, it's partially what he told the police, that he said, I can't identify him, I'd have to see him. So he repeatedly testified at trial that he clearly saw the taller robber's face. He was face to face with him. He came in, they had conversations, they had 2 conversations. He was never more than 4 feet away from him during the entire incident. And as the prosecutor pointed out, Major had a stutter. And as she plausibly argued, in summation, it could have been difficult for him at that time to give a description. He was asked, there's no testimony about whether he was asked for a description and he couldn't give it. The testimony is, he was asked whether, can you identify this person? And he said, I don't know, I'd have to see him. And that's exactly what he did. He saw him 3 months later in a photo array, and 4 months after that in the lineup, and then at trial. With respect to with respect to Wilson, he was held at gunpoint and not with the rest of the eyewitnesses, and he did focus on the shorter robber. But at trial, he recognized the defendant, and he testified about the description. He did have an opportunity to see the defendant when he was brought out from his office where the defendant was standing with the others, and he provided a description that fit defendant. And he recognized him at trial. He said, that's the shorter one, but with more weight. Of course, that's incorrect, but the fact is he did recognize him. So I don't think you could absolutely discount that identification. With respect to Mateo, I'm sorry, if you would just repeat what troubled Your Honor on that.
My understanding of the record is he identified him for the first time at trial, and he never viewed the lineup or the photo array.
Right, Mateo did not.
Right.
Now, I point out something interesting with Mateo and Wilson, and that is they both did correctly identify the accomplice. The accomplice himself testified, yes, that's me on the video, and he confirmed,
You're talking about the person who pled.
yes, and he confirmed their identification, and this court's decision in People v. Thomas, I believe, is very relevant, because the correct identification of an accomplice.
Okay, let me just stop you 1 second, because other judges have questions. But there's 3 witnesses there, and they're varying degrees of problems with their testimony. And then the last one was Anderson, and you got Anderson, and we're getting a description of Anderson through Detective Henry. See the problem?
Well, it's not a problem because the jury was instructed. It's not admitted for its truth. And it had a very relevant purpose. The detective testified that once he armed himself with these descriptions, he went out. The next step in his investigation was specifically to look for a video.
So the Anderson description then was essential for the detective to go out and look for a surveillance video?
Yes, because, first of all, this video was not recovered from the crime scene. It was around the corner in a private house. And without having descriptions, a detective would be hard-pressed to...
But counsel, did the detective need to give the description, although I think the description was pretty minimal, it was just height and weight, to convey to the jury that he had something that made him focus on these defendants as opposed to just 2 black men who might have been on the street?
I think, did he have to? No, but it was proper to do so, and it was more helpful for the people to elicit that. They're not constricted by the amount of evidence they elicit to prove their case. And if it wasn't connected, which I believe it was, the jury would just disregard it. It was a very important piece of evidence. The video, first of all, was a step to further the investigation.
Talking about the video was an important piece of evidence.
Right.
Right.
This detective, Henry, he didn't arrest the defendant. He only took the case to a certain point, and the video was an important piece of evidence on the people's direct case.
I'm still trying to understand why it was important for the jury to know what led him to find the video. Why would that, without that information, would it have made any difference to the jury at all?
I think it's more helpful to the jury, other than
In what
saying...
way? Helpful to do what? So what if he just said, as part of my investigation, I went looking to see if there was any video? To see if, maybe...
But why focus on a video around the corner from the location at a private home that the people are introducing into evidence? It's more helpful to understand that he obtained these descriptions.
Is your point that the jury would be confused, and then be distracted or derailed from its focus on the issues that are pertinent to the case by trying to figure out why you're going to look for a video around the corner?
No, I think
No?
that's
Okay.
extreme. I just think it was more helpful, and it was proper, and the people are not constricted by the amount of evidence.
But I think that's where Judge Stein I'm trying to understand what are you helping? What's the helping part?
I think it's more helpful for the jury to say, oh, he received descriptions of 2 black men, one big and large, one short and skinny, and recovered and went around the corner, viewed a video inside someone's home, and determined its value. And that's the video that we're seeing now. And if he had not been able to testify about that, would they have been confused? No, but it's just more helpful that the police conduct and the recovery.
That turns on, I'm just trying to follow this analysis. So that turns on assuming that what the cop sees on the video is an accurately reflects what he claims is the description that has been given to him. Correct, right?
Or comports with it, yes. Yes, correct. And
Counsel,
this-
do you care to take a moment and address your adversary's issues on the ineffective?
Yes,
Respect
I
the
just
submission.
want to end on one note that this issue is completely unpreserved. Had counsel brought to
We
the
understand that.
court's attention. Regarding the summation, I'll just say counsel was clearly not effective. The prosecutor's summation was fair comment on the evidence. It was responsive to the defense summation. which attacked the credibility of the identifications, and it was permissible rhetorical comment. And also, I would note that counsel did object to, he did move for a mistrial on the issue regarding the medical evidence and received very favorable instructions. And other than that, the prosecutor's summation was proper and even including...
Even the statements ridiculing Williams, you don't think that went over the line a little bit?
No, I don't, Your Honor, I don't believe they ridiculed him. I think that Williams' testimony was replete with inconsistencies, and the prosecutor was certainly able to comment on a witness, as she would any witness.
Thank you, counsel.
Thank
Counsel?
you.
Counsel, would you address the argument of the burden shifting in the summation that you claim?
So defense counsel did object to when there was the no medical documentation thing, but he only said the word objection and didn't explain what the basis of the objection was. And therefore, it appeared that the court, at least at that point, didn't really understand what the basis of the objection was and gave some instructions that were not to say that, the people didn't have a burden, the defense didn't have a burden, but, gave instructions saying that the jury can consider the evidence or the lack of evidence, further suggesting that the people can, that the defense, that the jury can consider the fact that the defense didn't introduce medical documentation. And
So do you agree, counsel, that with your adversary, that the hearsay objection didn't preserve the issue of the identification, at least with
No,
respect
the
to Anderson?
hearsay, as to Anderson, it preserved it. I mean, defense counsel said the word hearsay. The court made a ruling in response. The court was made aware of what the problem was and made an explicit ruling saying that this was being introduced for a non-hearsay purpose. And there was nothing more that defense counsel was required to do. And this issue is properly preserved for this court's review.
Thank you.
Thank you.